Special contracts between a utility and a single customer may be entered into so that a utility can provide service in a manner or at a rate not specifically covered by the utility's filed rate schedules and are subject to approval by the Commission. In its application, DTE indicated that the proposed special contracts, which include both a power supply agreement and an energy storage agreement, will generate an affordability benefit to DTE Electric's other customers by spreading the company's fixed costs, generation, and distribution over a larger customer base, and are intended to provide additional protections for the company's other customers beyond the standard tariff provisions. Under the proposed power supply agreement, the customer would take service from DTE under the existing D11 rate, which is available to large load customers who take service at primary, subtransmission, or transmission voltage. Taking service under the D11 tariff ensures that the customer will contribute to fixed system costs in the same manner as other large customers. In addition, the power supply agreement provides for a minimum contract duration of 19 years, a minimum monthly billing demand of 80% of the contracted capacity, a termination payment where the customer would be responsible for at least 10 years of the identified minimum charges, credit and collateral requirements, including a parent guarantee, as well as a letter of credit as necessary based on the parent's credit rating to protect existing customers from potential stranded assets or other financial harm. Under the proposed energy storage agreement, the customer agrees to pay for 1.383 gigawatts of energy storage facilities over a 15-year period. The storage resources would be procured by DTE Electric through self-builds, build transfer agreements, and tolling agreements with third-party developers, and specific storage projects would be subject to review and approval by the Commission in future applications. The amount of battery storage to be installed equals the electricity demand of the data center customer to ensure that DTE will have enough resources on the grid to meet the added demand. The terms of the proposed contract include similar termination payment and credit and collateral requirements as the power supply agreement. And while the battery storage facilities would be paid for solely by the new customer, these facilities would provide benefits to the grid as a whole. In submitting its application to the Commission, DTE Electric requested ex parte consideration of the contracts. Special contracts with customers are often reviewed ex parte, as the contract only applies to a single customer. In order to review the contracts through the ex parte process, the Commission needs to find that the rates and cost of service to other customers will not be impacted and may grant approval if the Commission finds the contracts to be reasonable and in the public interest. While a number of organizations and individuals petitioned the Commission to have this matter converted to a contested case, the order before you today finds that consideration of the proposed special contracts on an ex parte basis does not result in an increase to the rates, rate schedules, or costs of service for any customers, and thus is allowable under the law, as upheld through precedential court rulings, and is in the public interest. In addition, the order grants conditional approval of the special contracts. Specific conditions require DTE to do the following: commit that the customer's obligations under rate D11 and the special contracts will at least cover the costs to serve the customer, including generation, transmission, distribution, or other costs, and not be covered by other ratepayers, and file a letter with the Commission within 30 days indicating whether it accepts this condition. File within 90 days an application for approval of a generally applicable large load customer tariff for very large load customers such as data centers. File in its next rate case a cost allocation and rate design proposal that ensures that any future large load interconnection customers are paying the costs of interconnection, as well as a proposed administrative fee to be charged to potential additional data centers and other large loads to ensure the costs associated with any interconnection or other studies performed for these potential customers are not absorbed by existing customers. File an amended renewable energy plan with its next integrated resource plan and clean energy plan that includes a comparison of the resource requirements needed to comply with its renewable portfolio standard targets, both with and without Green Chili Ventures LLC's load and corresponding retail sales, an analysis of options for recovery of any incremental costs of renewable portfolio standard compliance, and an analysis of ways to recover the incremental costs of renewable portfolio standard compliance to ensure costs and benefits are appropriately distributed among rate classes. Include in its next IRP application and its initial CPP application a comparison of the resource requirements necessary to serve the utility's electric load with and without the addition of Green Chili Ventures LLC's load. Provide an updated analysis in its next capacity demonstration showing the impact of the data center's load on the utility's capacity requirements under direct loss of load methodology using the Mid-Continent Independent System Operator or MISO's most recent indicative direct loss of load results. Provide a detailed analysis in its next energy waste reduction plan filing of the incremental costs necessary to meet the 2% EWR savings target, inclusive of Green Chili Ventures load, and an analysis of updated surcharges designed to ensure other customers are not affected by the incremental EWR program costs attributable to the data center. Update its emergency procedures so that in the event of an energy emergency that requires the utility to involuntarily shed electricity load, the utility will ensure that the data center's load is reduced or interrupted before interrupting service to other DTE Electric customers. And finally, file quarterly reports beginning December 31st, 2026, detailing 1, the customer's load profile for the previous quarter, 2, the amount of storage that is operational as of the end of that quarter, 3, the customer's total demand for the preceding 12 months compared to expected contract capacity and minimum billing demand, 4, any changes to the customer's credit rating that trigger a change to the credit and collateral terms, and 5, DTE Electric's assessment of the financial state of the customer. On an annual basis, in every report filed on December 31st, DTE shall also include any other information related to the realization of the projected affordability benefit. Before closing, I would like to extend my gratitude to the staff of the Michigan Public Service Commission for their efforts in processing this application and preparing work. The technical staff worked diligently to conduct a review and audit to inform the Commission's consideration of this matter. Legal staff prepared a well-written and well-reasoned order. Our executive business section received, reviewed, and posted over 5,500 case comments to the eDocket system, and staff in the Commission office helped us support Commission deliberations and communications about this case, including holding a virtual public hearing and preparing an issue brief to promote awareness of the Commission's decision. The Commission and its staff have been entrusted through state law and are expected by the public we serve to ensure that the actions of this body are consistent with the public interest, and I commend this team for their professionalism and commitment to upholding that standard. Thank you.
Thank you for that excellent presentation, Mr. Byrne. I move for the approval of the order in case number U-21990.
I second the motion.
Is there any discussion? Excuse me. There's public comment as provided for in the agenda. Yep. There's public comment as provided for the agenda. It's the same place it is. I'm sorry, I'm not going to allow you to disrupt this meeting. Is there any discussion?
Yeah, I do have some comments. I would first like to thank everybody who took the time to comment on this case, either by written comment in eDockets, by virtual comment in our public hearing on December 6th, or in person here in our hearing room in Lansing. We've heard your comments and understand your concerns. I would also like to give a sincere thanks to our staff who spent countless hours reviewing every detail of these contracts over the last 7 weeks. You all put in a huge amount of time and effort into reviewing both contracts, as was described by Mr. Byrne, in depth to help us determine whether they are in the interest of DTE's existing electric customers. The decision before us today is whether the two contracts, the primary supply agreement and the energy storage agreement, signed by DTE Electric and Green Chili Ventures, are reasonable and prudent. The Commission's jurisdiction is for electric supply, and our decision needs to be based on what is in our jurisdiction, not other important considerations that were raised by the public, like water usage, noise pollution, or the merits of AI generally. The contracts that the Commissioners and our staff reviewed were the full, unredacted primary supply agreement and energy storage agreement. We were able to fully assess the implications and effects of connecting and supplying this 1.4 gigawatt load. We were able to review in detail the affordability model to assess how electric rates would be impacted as a result of this new customer. We were able to review the financial details of the credit and collateral requirements, including the amount of collateral, as well as situations when a letter of credit would be needed instead of a parent guarantee. We were able to evaluate the effects of a termination payment, of the 80% minimum billing demand, and the addition of 1.4 gigawatts of energy storage. This is our job as an energy regulator. It's our job to fully assess each and every case, every settlement agreement, every contract that's before us. Our staff are experts who have dedicated their careers to serving the public interest and protecting all Michiganders. We take our role seriously, and we understand the implications that our decisions have on Michigan's clean energy future and on people's pocketbooks. By law, the electric utilities in our state have an obligation to serve customers who want to take
That's your
electric
last warning.
service in their territory. The power supply agreement and energy storage agreement are well-negotiated, solid contracts. They show a net financial benefit to DTE's other customers of approximately $300 million per year. That is a real cost savings at a time when affordability is so important. The customer, Green Chili Ventures, is paying for 100% of the cost to build 1.4 gigawatts of energy storage that will add capacity to DTE's system commensurate with the capacity of the data center. The termination payment outlined by the contract ensures that if the customer leaves early, ratepayers won't be left on the hook for costs accrued to serve the customer. And the contract doesn't take for granted that the customer will remain financially solvent. It requires upfront collateral. In fact, the collateral of the contracts before us far exceed the 50% standard set forth in the November 6th order approving Consumers Energy's large load tariff. However, the order before us is a conditional approval. Even in the event that all these safeguards don't work the way that we think they will, the order places that risk on DTE, not on ratepayers. This approval is contingent upon DTE Electric agreeing to bear all the risk of any costs incurred that are not recovered from Green Chili Ventures. This means that if the affordability analysis turns out to be overly optimistic for any reason, DTE bears the responsibility of any extra costs, and they cannot be recovered from other customers. That also means that if the collateral is insufficient to cover all costs incurred in the event of a default, DTE's other customers will not be on the hook to pay. That risk is borne by DTE and its shareholders. If DTE is not comfortable bearing the risk, they're welcome to refile their application as a contested case. These conditions that all risk of increased cost is held by DTE and not placed on other customers is why I am comfortable voting to approve an ex parte approval for the order before us.
Thank you, Commissioner Pertic. Commissioner Murphy?
Sure. The commission received thousands of comments from citizens across Michigan regarding the proposed data center in Saline Township, with concerns surrounding rate increases due to the large load customer. Individual customers were concerned that they will be left with the costs if the AI bubble bursts or the needs of these large customers are never fully realized. Our authority for this case was related to the rates data centers pay for electric or natural gas service and the terms and conditions of that service. That includes guardrails to ensure there is sufficient power to serve all customers and that individual customers are not subsidizing these large load customers. The commission's review deemed the application to have met the standard for ex parte treatment. The conditional approval of the contract will not result in an increased customer rates or cost of service. The commission included conditions in the order to provide additional protections for Michigan customers to make certain customers aren't paying for the costs incurred by the data center. Those conditions include the company will be developing an energy storage project to cover the data center's maximum load, and of which the data center will bear all the costs. The contract includes an increased minimum billing demand, which will ensure there is an affordability benefit to other customers and will be applied regardless of the total demand. There's a minimum termination fee of $2.3 billion under the PSA and $3.9 billion under the ESA. If the customer decides to exit the contract, the termination amounts will still apply. All risks associated with the sufficiency of collateral will be borne by DTE Electric or the data center customer. No cost will be passed on to other customer classes or ratepayers. The ex parte application is conditioned on the assumption that the data center customer and special contract will cover the costs of generation, transmission, distribution, and other costs. Future rate cases will be the appropriate forum for rate making to assign costs to the data center customer so that existing customers don't experience a cost increase. If there are any concerns regarding the claimed affordability benefits and costs fall upon existing customers, the commission can at any time issue an order show cause.
Thank you, Commissioner Myers. And I just want to offer a couple of thoughts here as well. I understand there's a lot of frustration here. I do, and I want to provide some discussion of why I got here. So first of all, there was a fair amount of interest in the process around this, and as was noted, this is being decided on an ex parte basis, and as Mr. Byrne noted, under the commission's rules, we're allowed to approve applications on an ex parte basis where the approval does not have the effect of raising rates for other customers. I just want to note that this process is actually a fairly regular part of how we do our work. Earlier in today's agenda, for example, we approved 3 other applications on an ex parte basis. 2 involved requests from Alpena Power Company and Northern States Power Company seeking approval for their respective voluntary green pricing programs. And the third was the immediately preceding order, which was an application that requests from Northern State Power Company seeking ex parte approval of its revised depreciation rates. Perhaps more analogous to the current case, in recent years, we've also adopted a number of special contracts between DTE Electric Company and Ford Motor Company, Fiat Chrysler Automobiles, and the University of Michigan, related to how DTE would procure new renewable energy projects paid for by the customer to serve the customer's respective renewable energy goals. In December 2022, for example, we approved on an ex parte basis a special contract between DTE and Ford for up to 675 megawatts of new solar projects under a specific set of terms and conditions included in the special contract. We also approved, also on an ex parte basis, an amended and restated special contract between the same 2 parties last December that reflect additional provisions. In May 2023, we approved on an ex parte basis a special contract between DTE and FCA for up to 400 megawatts of new renewable projects. And in July of this year, we approved on an ex parte basis a special contract between DTE and U of M for 80 megawatts of new generation, again under terms and conditions laid out in the special contract. There are obviously some differences, including the size. The project today involves the largest project that we've seen. It's 1,383 megawatts. But there are some similarities as well. Together, just the 3 projects I mentioned total more than 1,150 megawatts, and that was all done in the last 3 years. Indeed, the contracts with Ford Motor Company and Fiat Chrysler Automobiles represent the largest and second largest voluntary renewable energy procurement contracts between a customer and a utility in U.S. history. Like today's order, those orders were groundbreaking. Like the contracts in front of us, those orders also required DTE to build or procure additional resources to serve customers. In the Ford, FCA, and U of M cases, it was solar. Today, it's battery storage. And like the contracts in front of us, there were a number of provisions that were redacted for a variety of reasons, including subscription charges and customer default provisions that are commercially sensitive. And so while I recognize the concerns that have been raised around the process in this case, the reality is that the Commission used a very similar process in a number of other instances, including in similar cases in just the past couple of years. Approval on an ex parte basis is also consistent with applicable law and court precedent. A lot of the discussion in various filings in this case centers around a Michigan Court of Appeals case from 1997 entitled Attorney General versus Public Service Commission. And in that case, like here, the Attorney General, then it was Frank Kelly, appealed a decision of the Commission in which it approved a utilities proposal on an ex parte basis that was also involving a special contract. The Attorney General in that case, again, Frank Kelly, argued that the Commission had gotten it wrong. And argued that it wasn't enough to say that the specific approval of the special contract wouldn't pass along additional costs, but that no additional costs could ever result from the special contract. And the Court of Appeals ultimately disagreed with Attorney General Kelly and said, no, it's really the effect of the order in front of you approving the special contracts. If that doesn't by itself increase costs, then the commission is within its rights to use the ex parte process for approval. But what I'd note is that I believe that in the order in front of us, we're actually holding ourselves to the higher standard articulated by Attorney General Kelly in that case, that it can never result in additional costs being borne by other customers. And that's the condition that we put on the approval in this case. I also, ma'am, I need to ask you to leave. My second point is the role of the staff in this, because there's been a fair amount of concern that, as was noted earlier, that these contracts were never actually reviewed. And that's just not true. Our staff plays a critically important role, as Mr. Byrne identified, in ensuring that the public interest is represented in our proceedings. In fact, in a number of orders and upheld by the courts over decades, we have found that the staff's participation alone in a proceeding ensures that the public interest is adequately represented, including in the entering into settlement agreements. And we had a number of those cases on our agenda today as well. The staff also has unique audit powers, particularly in cases where they are the only party other than the utility participating in the case, such as here. That ensures that we can ask questions, test assumptions, reproduce modeling results, in short, perform the critical oversight and regulatory roles that are the foundation to the reason why public utility commissions or public service commissions exist. We don't take things on faith, and our staff is critical in making sure that even in cases that we're reviewing on an ex parte basis, that we have all the facts in front of us before we move forward. A third concern was confusion or concern about what was in the contracts, particularly the redacted provisions. And I know that this has been addressed, but I just want to flag a number of issues here, because I think the details matter in this case. I think they matter in all cases, but I think they particularly matter in this case. So under the generally applicable D11 rate under which the customer could otherwise have taken service, there is a minimum contract duration for any customer of a megawatt or larger of 5 years. In the contract that we have in front of us today, that's nearly 4 times as long, a minimum contract duration of 19 years. Under the generally applicable D11 rate, there is a 50 to 65% minimum billing demand. In the special contract that we have in front of us, that's 80%, meaning that data center operators will have to pay a minimum of 80% of the contracted electricity use, no matter how much they use if their actual use is lower. If it's higher than 80%, they pay their actual amount. But that's a significant improvement around the otherwise applicable contract terms. In the generally applicable D11 tariff, there is no explicit reference to a termination payment included in that tariff. In the contracts in front of us today, the termination payment is up to 10 years worth of minimum billing demand if the facility stops operating earlier than contracted. And that, I think, provides billions of dollars in revenue, guaranteed revenue, as Commissioner Myers noted. And then finally, there were a number of questions that were raised about what happens if this is a bubble. What happens if this ultimately just goes away or the whole system collapses? And so we spent a significant amount of time around the credit and collateral provisions that were included in the contracts. And effectively, both the power supply agreement and the energy storage agreement require the customer to guarantee all payment obligations under each agreement through a combination of parent guarantee and, if applicable, a letter of credit that includes any termination payments that would be required if the customer voluntarily terminates or defaults. And whether the letter of credit is utilized and the level of the letter of credit is determined based on the credit score of the customer. And so this provides real protections that don't exist in many other states to ensure that if ultimately this is a bubble, if this is all overblown and the load doesn't materialize, that again, even in that worst case scenario, customers are still protected. But we went further than that and conditioned, as has been noted, our approval on the additional commitment from DTE that no costs, even in that scenario or any other, will ultimately be passed on to other customers. Additional requirements, as Mr. Byrne noted, in capacity demonstrations, integrated resource plans, and clean energy plans, and renewable energy plans that are designed to isolate the impact of the data center to better track costs so that we've got full awareness of what costs were triggered by the data center and which were not, so that we can enforce the condition that no costs are ultimately borne by other customers. A series of filing requirements, a requirement to file a generally applicable data center tariff supported by 6 cost of service studies, and that will be reviewed in a contested case. And then, as Mr. Byrne noted, some provisions around shutoffs in the event of ultimate grid shortages. And this was also in relation to questions raised of what happens if we don't have enough power on the system, even after adding 1.4 gigawatts of batteries, who gets shut off first? And our order is very clear that it is the customer. And that can either be directly or it can be through a curtailment arrangement, but the customer gets shut off before any other DTE customer gets shut off in the event of a lack of grid power. So ultimately, those provisions, both what was included in the contracts, including the redacted contracts that we and our staff were able to review, as well as the additional conditions that we imposed, led us to believe that we could meet the standard of reasonableness and in the public interest in approval of this. And I would say, I know that this conversation is happening in every state in the country right now, and I would put the contracts that are in front of us today on par or better with any that have been approved in the country. We will now have a vote on the motion to approve the order. All those in favor of the motion say aye.
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 Aye. Any opposed? The motion carries by unanimous vote. The order in case number U-21990 is approved.